Hi everybody and welcome back. Today we're going to be talking about pretrial publicity and how that affects the outcome of a trial. So with pretrial publicity we're going to talk about a lot of different things. Right? We're going to talk about the jury, we're going to talk about when your rights clash with each other, what qualifies as pretrial publicity, how we study it, how does it affect juror decisions, and also some recommendations for reform. So first of all, what is pretrial publicity? We all should be very familiar with some cases of pretrial publicity, right? If we look at these pictures here, we see Casey Anthony and also the Special Olympian who had no legs. I can't recall his name right now. And a lot of things about them that were shared pre-trial, right? Casey Anthony, I think everyone pretty much agreed that she was somewhat of an unfit mother, right? And so we saw pictures like this of her smoking a cigar and drinking some scotch, allegedly while her daughter was missing. And how does that affect the outcome of the trial? Now, we do have a lot of different rights here, right? And it's interesting to see how these rights kind of interact with each other, right? So we have the Fifth Amendment that says no person shall be held to answer for a capital or otherwise infamous crime, a felony, unless on the presentment of an indictment of a grand jury. So what this means is that without a grand jury indictment, or in some states like Florida, a prosecutorial information, you can't actually be charged with a crime, right? The Sixth Amendment says that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law. Again, this is interpreted to mean a representative jury of one's peers from the jurisdiction in which they came, right? And it's supposed to be an impartial jury, right? The Fifth Amendment is another right that we have that states that in suits of common law where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law, right? So even in civil litigation, the Seventh Amendment says that you have to have a jury of your peers, and that no fact shall be tried by a jury shall be otherwise re-examined, except for in the courts by the rules of common law. Now, all of these things are protecting the defendant, right? The Fifth Amendment says that you can't be charged with a crime unless there's an indictment or a prosecutorial information. The Sixth Amendment says that you have the right to an impartial jury of your peers. The Seventh Amendment says in common law or in civil law cases, again, you have that right to a jury of your peers, and no one else is allowed to judge you but this jury of your peers. Now, take all of those rights that protect the defendant and compare it to this. The First Amendment of the Constitution says that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So we have these rights that says no one is allowed to judge you but the jury. You're not allowed to get charged, or you can't be charged unless the prosecutor decides to charge you. But we also have this right to a free press and free speech, right? And so how do those rights interact with each other? Could Casey Anthony or George Zimmerman or any O.J. Simpson, could they get a fair trial because of all of the publicity that they had? So pretrial publicity is defined as a debate between the right of a free press, the First Amendment, and the right to an impartial jury, this Sixth Amendment, right? Media reports often have this prejudicial case-relevant information in them. This information may not be admissible at trial, but could still cause a potential juror to prejudge the defendant's guilt, right? Let's say that George Zimmerman's prior criminal record before the shooting of Trayvon Martin was not allowed at trial, right? Everyone knew about it, though, if they watched the news. And so isn't that kind of an issue? It could also cause an increase in bias against the defendant and can affect pre- and post-trial guilt judgments of mock jurors, all right? And so there are a lot of different kinds of bias that can be, right? There's a pro-prosecution effect, right? In the case of O.J. Simpson or George Zimmerman, or even Casey Anthony, everyone knew that that person was guilty before the trial started. Everyone thought so, right? O.J. Simpson is guilty. Casey Anthony is guilty, right? There's also a pro-defense effect. There are some people where it's like, why are we going through the motions here of a trial when we know they're going to get found not guilty, right? If you ask a lot of police officers after officer-involved shootings, they'll all say, oh, you don't understand what the cop went through. Like, the guy, this is a waste of time, this is a waste of the cop's money to try and get him convicted. There are a lot of categories of pretrial publicity also, and they're not necessarily, this list is not exhaustive, but these are the different types of pretrial publicity. There could be information about the defendant's prior record, which could largely be irrelevant. Could be information about the defendant's character, a confession or admission from the defendant, even if the information about the defendant's refusal to confess could be an issue. Whether any examination has been performed on the defendant, and any opinion about the defendant's guilt or evidence in the case, right? And so there's a lot of different ways that this could play into effect, right? A lot of people that thought George Zimmerman was justified in shooting Trayvon Martin pointed to the fact that he had prior drugs in his system and also prior drug issues. People who thought George Zimmerman was super guilty had information again about the defendant's character. If somebody was examined, right, by a psychiatrist or a psychologist, people want to know what those effects are, what those results are of that examination. So this is kind of a cute little cartoon here, right? But this is really, for researchers who study pretrial publicity, this is what a jury box actually looks like, where jurors might actually just be spouting back information that they've heard on TV or in magazines and newspapers or on the radio. So with pretrial publicity, what can we learn? Well, first we have to talk about how we study pretrial publicity, and then we have to figure out what effect pretrial publicity has on jurors' decisions, if any. If there is an effect, how do we fix the problem? And then also, again, this is a psychology and law course, what role can psychologists play in the courts to talk about or combat this pretrial publicity? So how we study pretrial publicity. One way to do this is survey research, right? And so this, we can assess the effect of pretrial publicity in actual cases by giving surveys to the community, right? We can see the extent of the exposure, what kind of information is learned, what the perceptions of guilt are, and then, we can compare that to other venues. And see, like, for example, if a crime happened in St. Augustine, is the pretrial publicity biasing a pool of jurors in St. Augustine compared to, say, another small town along the coast like Palm Coast or Melbourne or Clearwater or something, right? There's also a content analysis, and we can examine the information given by the media, right? Pictures, texts, headlines, how much space is given, and you can compare that information to other venues. A very famous case that was, this kind of research was done, was Timothy McVeigh. Timothy McVeigh was obviously the Oklahoma City bomber who blew up a U-Haul truck full of explosives at a government building. What researchers did was they did a content analysis of 4 newspapers representing possible trial venues, and they accounted for the amount of pretrial publicity and the content of that publicity. And what they found was actually super interesting. In Oklahoma City, obviously, a lot more media attention was given to the Oklahoma City bombing than in other cities in Oklahoma, and then they had a comparison group in Denver. And they found that a lot of people knew someone or were in some way related to a victim of the bombing. And they had a lot of emotional stories about kids whose mommy and daddy weren't going to come home, parents whose kids that were at the daycare that blew up were not going to have their children anymore. And then they did a public opinion survey to find out if people had more information and whether there were these emotional connections to this bombing. And what they found was all the newspapers in Oklahoma, 3 of the 4 newspapers were from cities in Oklahoma, they all had these emotional stories, and they all dedicated a lot of time and a lot of energy to this bombing. The newspaper in Denver still had some emotional stories, but it was mostly factual. There weren't a lot of stories about what the owner of the restaurant thought down the street or anything else, because Denver's pretty far away. As far as public opinion surveys, they actually found that people in Denver were less likely to have as strong of a negative emotion against Timothy McVeigh compared to other people in Oklahoma. And so if you were an expert, what would you recommend here? Maybe the only way to actually give someone a fair trial would be to move the trial out of Oklahoma to another city. right? And in the case of Timothy McVeigh, that's exactly what happened. They actually tried Timothy McVeigh in Denver, not in Oklahoma, because of the extensive amount of pretrial publicity. There was fear as to whether or not he would get a fair trial. What's interesting is the exact opposite happened in the case of the Boston bombers. The people of Boston wanted the trial there, the judges wanted the trial there, the police wanted the trial there because Boston wanted to punish the Boston bomber for what he did to Boston. So how do we study pretrial publicity? Well, laboratory studies allow us a lot of great information. They allow us to determine cause, right? And so you can see if two different groups give different verdicts based on pretrial publicity, right? Now, granted, there's some pros and cons to this, right? Some pros are that it allows us to determine cause, but this might be somewhat of a contrived or not very ecologically valid simulation. So we have this pretrial publicity, right? One group has pretrial publicity, one group has no pretrial publicity at all. Then they both read the exact same trial stimulus. And then we look at the guilt ratings of the people that in the pretrial publicity condition and compare it to the guilt ratings of the people in the control condition to see if there's any differences between the two. What we found in these kind of simulation studies is that jurors exposed to pretrial publicity are significantly more likely to render guilty verdicts than those not exposed. Also, the voir dire process does not change the effect of pretrial publicity. So in theory, we do this voir dire or jury selection, which we'll talk about in the next lecture, that is supposed to drastically reduce the effects of pretrial publicity. Unfortunately, it doesn't really do that. Or really just, voir dire is really just supposed to take out any sort of bias, pretrial publicity included. Jury instructions don't change the effect if we instruct the jurors not to use pretrial publicity. Asking jurors to disregard any information learned outside the scope of the trial is not effective. And jury deliberations even have not been demonstrated to change the effect of pretrial publicity. In fact, as in my job as a trial consultant, I have seen several jurors say, I heard about this on the news, or I saw that, even when we go in the room and say, hey, you guys can't really talk about that, and then come back out, they'll still bring it back up again and say, yeah, but I heard that somewhere, so we need to take that into consideration. We know that negative pretrial publicity adversely affects guilt judgments, such that obviously if they view the defendant as more guilty, it indicates that the defendant has bad character, or indicating that the defendant has bad character also has a significant biasing effect on the jury. Positive pretrial publicity is less biasing toward the defendant than negative pretrial publicity, and jurors have trouble distinguishing sources of information. And so we don't remember, did I hear that at the trial or did I hear that on the news? I can't remember where I actually remember hearing that thing. And negative pretrial publicity also has an additive effect on juror judgments of guilt. So they've heard all this negative stuff, they pile that on top of the negative pretrial publicity they've heard, and now they've heard significantly more information on negative as opposed to positive about the defendant. So does pretrial publicity affect jurors' decisions? Well, in a meta-analysis of 44 studies with over 5,000 subjects, there were a couple goals that they tried to determine. They tried to determine if pretrial publicity actually does negatively affect juror judgments. If a negative effect occurs, what are the conditions under which the effect is the most likely to occur? They examined the impact of methodological variations of the research on pretrial publicity, and they also identified areas for future research. So in the first question, pretrial publicity affect juror decisions? What they found was that negative pretrial publicity influences jurors' pretrial and post-trial judgments of defendants' guilt in both criminal and civil trials. And they found in this meta-analysis that the hypothesis was confirmed that there was a small to medium effect here. So if we look at the guilt ratings for people with pretrial publicity, 59% of people viewed the defendant as guilty, as opposed to 45% when pretrial publicity was not present. There are two main types of pretrial publicity, and you will definitely need to know these for the exam, so please make sure that you understand these. There are case-specific pretrial publicity, right? This is media exposure to a certain case that affects jurors' attitudes about the case, the defendant, the plaintiff, or beliefs about the defendant's guilt, which then affect jurors' case judgments, right? And these could be emotional or they could be factual. George Zimmerman's racist, right, is an emotional thing. That's why he shot Trayvon Martin, because he's racist, right? There was no real evidence to suggest that he was racist, and in fact, a lot of the pretrial publicity that talked about him saying the guy looks black, we eventually found out was actually the media biasing the public on purpose to make this a racial issue. And there's also factual pretrial publicity. George Zimmerman wanted to be a cop, but failed out of the academy. George Zimmerman was captain of Neighborhood Watch because that's the closest he could get to actually being a cop. George Zimmerman was a concealed carry permit holder and was carrying a gun and did so often, right? Factual things that might bias people against him. So we've got case-specific pretrial publicity that affect case attitudes, that affect case judgments. So, for example, right, we could see factual pretrial publicity in the case of BP and the oil spill, right? Factually, what happened? Well, there was an oil spill. Here's a picture of an oil spill. Something burst. There was an oil spill. That affect attitudes about BP's negligence, and therefore affected negligence verdicts in BP's case. The same thing was also true when you looked at other things, right? Like, look at the poor animals that are dying. That's much more emotional. Or this family is now starving to death because their livelihood depends on fishing, and the fish are all dead. Very emotional, right? This actually makes stronger attitudes about BP's negligence, and therefore there are more negligent verdicts in the BP case, right? And so that's really case-specific pretrial publicity. General pretrial publicity. And this addresses a topic in general, right? This is media exposure to topics not directly related to the case that affect attitudes about the general topic, which in turn affect jurors' decisions on trials that have to do with these topics, right? And these are much weaker effects than case-specific pretrial publicity, but still have somewhat of an effect, right? So, for example, Dateline, when eyewitnesses are wrong. If you've seen that, you might be more skeptical of eyewitnesses. Or watching CSI, you might expect there to be more forensic evidence than there is, although the CSI effect we've shown has been pretty weak. And so what we see is the way we test this is general pretrial publicity, attitudes about the case topics, interpretations of the evidence with these attitudes about case topics, and then case judgments. So more specifically, we see issues with eyewitnesses, right? Which affect attitudes about eyewitnesses, which affect interpretations of eyewitnesses, which means there are more not guilty judgments because of this general pretrial publicity. Now, what do we do about all this? Do we just say the media no longer has their First Amendment right to talk about cases? That probably wouldn't go over well, right? Do we say, okay, well, defendants just have to be okay with not getting a fair trial? Well, I think a lot of people would shudder at that thought also. So, forms are doing things in voir dire, where attorneys and judges ask questions of potential jurors about biases they may hold that would prevent them from hearing the case fairly. In cases with pretrial publicity, maybe extended questioning would be allowed. The problem with effectiveness, and we'll talk about this further, is that attorneys are really bad at jury selection. And in fact, and again, I'm spoiling stuff for future lectures, but if you compare random number table picking jurors to attorneys picking jurors, there's really no effect on outcome. So attorneys are really bad, and so are judges at jury selection. Also, it assumes jurors know their own biases, right? Do you know that you've been biased by pretrial publicity? Do you know you've been biased in a certain way? Most people won't admit that they have been. Also, can jurors really be accurate in reporting that pretrial publicity will not affect them, right? Let's say that you find out that your best friend's boyfriend cheated on her, all right, or him. Are you able to discount that information and never think about that information? Are you ever able to interact with that person and it's like, hey, I told you that he cheated on me, but please, don't treat him any differently? Are you good at not treating that person any differently, having that knowledge? Most of us aren't. The research, again, on all of these things says that this is probably not a really good reform here, even though a lot of attorneys and judges push for this. There's also judicial instructions. The judge just tells the jurors to avoid being influenced by pretrial publicity. Important to rely solely on the trial evidence, right? There's a big problem with effectiveness here also, right? Jurors generally don't follow judicial instructions to disregard inadmissible evidence. In fact, if a judge says don't listen to that or ignore that last statement, jurors consider it more often than not. Providing a rationale as to why may help, but there's not big effects, right? Jurors are generally also not great predictors of what affects their behavior. And in fact, again, research on this suggests that jurors really only understand about 20 to 25% of the judicial instructions given to them anyway. And so who even knows if they'll understand what the instruction is that they're given? Another recommendation is that we should just continue the trial. A continuance in a legal sense just means that you kind of kick the trial date down the road, hoping that pretrial publicity will die down, right? Delay the start of the trial. Some studies have shown a sleeper effect, which is just kind of the tendency to be more influenced by unreliable information over time as memory for the unreliable source becomes detached from information, right? So you might have read someplace about Princess Diana dying on a tabloid at Publix, right? Princess Diana died, 20 years ago. You might say, hey, I heard that she was high on cocaine when she died, but then you can't remember. Did I hear that on CNN or was that on the National Enquirer? Golly, I can't remember. And that's kind of what this sleeper effect is. It may work for factual pretrial publicity, but the effects of emotional pretrial publicity are quite pervasive over time. Once people have a negative opinion about someone, even still, how many people avoid going to BP, especially native Floridians, because of the effect BP had on our economy that they didn't really ever pay back? Right? Obviously, now this idea needs more work, in large part because studying continuances, it takes a tremendous amount of time because, if you wait 3 years before you start a trial, that's 3 years you just have to wait around before you can even do your study. Another recommendation is a change of venue motion, right? And this basically is if the court is satisfied that there exists in the district where the prosecution is pending so great a prejudice against the defendant that the defendant cannot obtain a fair and impartial trial at any place fixed by law for holding court in that district, essentially the trial can be moved. It may be supported by field studies examining jurisdictions or comparing jurisdictions with the extent of the pretrial publicity and the type of the pretrial publicity that is present. This is what happened in Timothy McVeigh's case. Now, granted, Timothy McVeigh was still found guilty, so maybe the change of venue didn't matter all that much. Suggests, though, that this is the most effective method. This is the method that will change the results and take out as much bias as possible. In certain cases, though, a different venue can still be tainted. Could O.J. Simpson have gotten a fair trial anywhere in America? Probably not. Could Timothy McVeigh have? Probably not. Could the Boston bomber have? Probably not. However, the amounts and types of pretrial publicity may differ. And if you think about it, right, especially for those of you who have gone to death row with me, pretty much everyone on death row that we've met and talked to and interacted with, you had never heard of prior to going to death row. However, the city where those people committed the murder, a lot of people have probably heard of them, right? Especially if it's a small town. So let's say someone in Palatka committed a series of murders. In St. Augustine, we might not have ever heard about it. So them being tried here might actually reduce quite a bit of that emotional and factual pretrial publicity. So that's all we're going to talk about today for pretrial publicity. As always, if you have any questions, please let me know, and I will see you all next time.